Hey, I'm Tom Gallagher. I'm one of the managing attorneys at Gallagher Krich APC in San Diego, California. We do small business law, consulting, corporate litigation, and business organizations for small to medium sized businesses in our region. Mediation is an informal, neutral driven, confidential process that's going to allow the parties to shape a solution to any kind of problem that they have and avoid the cost of litigation. So, first and foremost, mediation is an informal process. It's not going to be in open court. Usually, you're going to be with a retired judge or lawyer with a lot of experience in your practice area. Oftentimes, you'll see these in business cases, real estate cases, where you're going to sit down possibly before you even begin to file a lawsuit so you can try to work out any differences and avoid the high cost and drama associated with the lawsuit. So the mediator is an informal, neutral party who does not have a stake in the outcome. However, they do have a lot of experience. Typically, they might be able to consider legal arguments. They're not going to rule on anything. So you're not trying to persuade them as you would with a judge or a jury. What you're trying to do in this situation is basically share ideas on how you might be able to settle your case or basically have a back and forth exchange of numbers and justification as to why the other party should want to reach a resolution with you. What the neutral is going to do is facilitate that dialogue and help you have a free exchange of ideas and take the negative comments or hostility, drama out of the situation and help you focus on what is really important, be hard on the problem and soft and understanding on the people. You might have a mediator who is going to listen to your particular justification, but they're not going to make any kind of ruling, and nothing that they say is going to be binding on the parties unless they both agree voluntarily to reach an agreement. Sometimes you will see a combination of attorney fee shifting and a mediation clause. Often in real estate matters, you'll see that. So you're going to have a prevailing party being able to recover their attorney's fees and cost. However, if the parties do not go to mediation, or if one side refuses to go to mediation, the other party might be entitled to their attorney's fees, whereas the party that refused to go to mediation could be barred from getting recovery of their attorney's fees and costs. So it's important to try to attend within 30 days of someone making a demand on you when you have that clause in your contract. Again, you often see that in real estate contracts. You need to be very aware of that before going to court, you need to at least try one or maybe even two mediation sessions, maybe a half day, something like that, a couple hours. It's not going to be a waste of time. Most of the time, you're going to learn a few things about the case, about its strengths, perhaps the weaknesses that you might encounter that you haven't thought about before, and ideally try to work something out and reach an outcome that would avoid a lot of the time and expense and frustration associated with the lawsuit. So mediation is also voluntary, meaning that both parties can choose to walk away at any time. That means that if you are frustrated in the process not working the way you expected or you don't think it's going anywhere, you can leave the table. That is an acceptable thing to do. And oftentimes, what you're trying to accomplish is just avoid the inevitable problems and maybe try to have a cost savings for both sides. Another important aspect of mediation is that it's a confidential process. You can exchange documents and ideas at the mediation and ask that they be kept confidential so that if you make some kind of admission or apologize during the mediation process, that cannot later be used against you as evidence that you admitted to X, Y, or Z. Both parties will sign a confidentiality agreement at the beginning that they will not try to introduce statements made or documents that they obtained from the mediation in a later proceeding. Now, of course, if they are otherwise discoverable, perhaps you have produced them in discovery responses, that mediation is not going to make them non-discoverable just because you had a mediation. But if you were to have a mediation and write some numbers down in terms of an offer that you're going to make, that type of document is almost certainly going to be excluded. So you can feel free to exchange your thoughts or your motivations or a settlement offer in confidence, and you don't have to worry about that being used against you later. And another reason that the parties might be willing to attend a mediation session is that the costs are typically much less than you would see in terms of filing a lawsuit or going to arbitration right off the bat. Typically much cheaper, faster, and fulfilling to get a result at mediation if you have more control over the types of offers that you're going to make, if you have more direct agency in saying, this is something that I'm willing to consider, this is something that I'm absolutely not going to consider, and would walk away from the table if necessary. So you're not going to have any kind of result dictated to you. This is something where you're more in control of the process. You can shape the outcome with the assistance of your attorney, who might be there to provide some guidance, but you're not going to be making arguments. You're not going to take everything out of your hands and put it in the hands of a judge or a jury to decide the outcome for you. You and the other party are more directly involved in reaching a mutually satisfactory outcome. Another benefit of mediation that we discussed earlier is the fact that it's going to avoid the costs associated with litigation. Now, typically in California, you're going to be looking at extensive delays caused by COVID-19, and unfortunately there's not much that anyone can do about it to speed up that process because you have a number of cases that are just backlogged in the system. The California courts were already facing budgetary problems before, so the situation right now is one where if you are filing a lawsuit today, typically you're not going to get to any kind of trial or resolution for perhaps 2 years. It's not inconceivable that that is the fact of the matter. And on a monthly basis, you're spending money. You are getting frustrated perhaps with the process and how long it's taking and the stress that it might be causing you. There's a lot of uncertainty involved in that situation as well. Thanks again for watching our video. I hope you learned a few things about mediation clauses and how mediation might be of benefit to parties as a great alternative to litigation. If you have any questions, if you want to just look around our website, we have a lot of resources here that explain things further. There's a transcript of this video and also some sample mediation clauses. If you have further questions beyond that, if you give us a call at 858-926-5797 or follow the link on our contact page, we'd be happy to work with you to develop mediation clauses in your agreement, or perhaps explain how to prepare for a mediation and represent you in a mediation if you have one upcoming.